Good afternoon. Good afternoon to everybody. Welcome to Constitution Day 2025. I'm Karen Tokarz, longtime member of the faculty here at the law school, director of the Negotiation and Dispute Resolution Program, and the coordinator of the Public Interest Law and Policy Speaker Series, formerly known as the Access to Justice Series, which is now in its 27th year. First, thanks much to the WashU Law School staff for their invaluable tech, admin, and PR assistance. We could not do any of these programs without all of you. Second, thanks much to our co-sponsors for today's event, the Gephardt Institute for Civic and Community Engagement, the Weidenbaum Center on Economy, Government, and Public Policy, and the Law School American Constitution Society student group, which has graciously supplied pizza in most years, and this year, somehow sandwiches. Those of you who are history buffs know that Constitution Day is officially celebrated every year on or about September 17th, which happens to be today, to commemorate the signing of the U.S. Constitution at the Constitutional Convention in Philadelphia in 1787. Constitution Day, as you may know, conveniently precedes First Monday, the first day of the coming U.S. Supreme Court term, which is always the first Monday in October. This year, Monday, October 6th. For well over a decade and a half, it has been the university tradition and the law school tradition to celebrate Constitution Day with a SCOTUS review, sometimes preview, here at the law school, where we highlight major cases from the last Supreme Court term and examine major trends as we look forward. Every year, commentators across the country attempt to describe and characterize the prior year's cases and the impact of the court. You hear terms such as blockbuster, contentious, monumental, given that every year there are high-profile cases, almost always much debate among the justices, multiple dissents, and much debate among lawyers and the public. This year, perhaps more than ever. This last Supreme Court term marked 20 years of the Justice John Roberts Court. He started as Chief Justice in September 2005. Early on, Justice Roberts more visibly struggled to maintain an institutional center, but he has increasingly hovered toward the right, in part due to Trump's three appointments, Gorsuch, Kavanaugh, and Coney Barrett. The ideological split on the court is more prominent than ever before, and for some, has significantly diminished public faith in the court. For the past and upcoming term, again, and apart from the cases, important issues include public concerns about increasing politicization of the court, the lack of ethical restrictions on the justices, and the increased use of the emergency shadow docket, cases in which the court rules summarily and somewhat immediately with limited briefing and no oral argument, overturning lower court rulings on an emergency basis without providing signed opinions or detailed explanations. You will hear more about this from Professor Epps, but I mention it now for two reasons. One, I want to highlight an article on the front page of this past Sunday's New York Times, citing research by WashU Law Professor Lee Epstein, Chancellor Andrew Martin, and Professor Michael Nelson, comparing the rate of such emergency shadow docket rulings under President Trump, almost twice the number under the Biden administration. And two, to highlight for some of you, those of you who are unaware, that the university library now provides free subscriptions for students to the New York Times, the Guardian, the Post-Dispatch, and other news sources, which gives you an opportunity to track the activity of the Supreme Court. If you're interested, contact the Olin Libraries. Clearly, in one way or another, the decisions and the policies of the U.S. Supreme Court greatly touch all of our lives. At this moment in time, perhaps more than ever, the court's decisions are in many instances the final word. As always, some of the cases and policies, as I mentioned, are controversial and hard to comprehend. To help us understand and make sense of it all, we are fortunate to have with us today a panel of 4 top Supreme Court experts from our law school faculty who will give you their views on a handful of major cases from the 50-plus cases of the last term, targeting First Amendment issues, free speech, gender and sexuality issues, shadow docket, presidential power and removals, plus some important cases on the horizon, and some insights about the court as a whole. But unfortunately, we can only touch upon some of these target areas that the court has recently addressed. And we're going to go in this order. To my left, Professor Greg Magarian, former U.S. Supreme Court clerk and nationally recognized constitutional law expert, particularly on the First Amendment. Professor Susan Appleton, nationally recognized expert in family law, gender, sexuality, and reproductive rights. To her left, Professor Dan Epps, former U.S. Supreme Court clerk and constitutional expert who focuses on federal courts, including Supreme Court reform, and on occasion he co-hosts a Supreme Court podcast. And fourth, Professor Andrea Katz, a constitutional expert who focuses on presidential power, legal history, and political theory. Each will speak for approximately 7 minutes. We will take one question from the panel in between the speakers, and then take a few questions from the audience or from the chat to the degree that we have time. Unfortunately, as you know, we must end today around 12:52, given upcoming classes. You are welcome to come up front afterwards if you have remaining pressing questions. Please note that this program is being recorded and will be posted on the Public Interest Law and Policy webpage. Thank you again for joining us. Professor Magarian.
Well, thank you. And before I talk about a couple of cases, I just want to thank you all for being here. It's exciting to see such a big turnout, and I think it's important because discussion of these issues, in my mind, has never been more salient to what's going on, importantly, in the world. This is, to my mind, the greatest moment of constitutional foment and churn and crisis that I've seen in my lifetime. There was a moment in the years after the 9/11 attacks that was pretty, raised a lot of constitutional hot-button issues, but I think this moment is far more in every aspect of constitutional law. Crises based on executive power. We have a Congress that's largely dysfunctional. And most salient to today's discussion, we have a Supreme Court that has its most ideologically coherent and strong majority in well over 50 years, which is the thing that makes the Supreme Court probably most powerful and decisive in its actions. The constraints on the Supreme Court's actions are mostly internal. And with a majority that largely sees eye to eye, those internal checks become a lot weaker. So, we're here at a law school, and the beginning of the semester, there's all kind of stuff going on, and looking around, you almost wouldn't know that there was all this important stuff happening in the legal world, the constitutional world, outside our doors. So I just want to encourage you to thank you for paying attention to this stuff. Keep paying attention and demand more from us. Ask us for clarity and whatever insights we can provide, because that's what we're here for, and it's important. Now, I just want to talk about a couple of First Amendment cases, and as I do so, Professor Tokarz, every year when we do this, gives us all little gifts, despite the fact that she's the one who does all the work and puts this all together. And with this year's gift, it gives me an opportunity to see if it's possible for an audience to take someone seriously as a constitutional law expert while wearing a fuzzy ghost headband. So we're gonna see how that goes. All right, I want to talk to you about 2 cases, one dealing with free speech and one dealing with religion. I know, right? It's hard. I'm up here, words are coming out of my mouth, and they got little ghosts. Last term was not a huge term on the free speech side, but there was an interesting case. Okay. That's fine with me. Called Free Speech Coalition versus Paxton. This is a case out of Texas. Texas enacted a law requiring essentially commercial pornography websites to require credit card verification as a form of age verification before someone can access the site. This is based on a long-standing legal doctrine, usually called the harmful to minors doctrine. And what that doctrine says is states, the federal government, governments are allowed to regulate sexually explicit speech that is harmful to minors or inappropriate for minors but not for adults. So there's sort of a bifurcated First Amendment standard for regulation essentially of pornography. But the catch with the harmful to minors doctrine is states emphatically may not simply ban speech for all audiences, including adult audiences, because that speech is harmful or inappropriate to minors. States can only take incremental steps to make it harder for minors to access that material. So the question in Free Speech Coalition versus Paxton was whether this credit card verification requirement went too far in encroaching on adults' First Amendment rights as the state was trying to protect children. And the Supreme Court answered that question, no. The court upheld Texas's law and said Texas may require credit card verification in these circumstances. The reason that I think this case may be important is that it has been unusual for the Supreme Court in recent years to impose restrictions on just straight up free speech and the free speech rights of adults. The court has been pretty libertarian, to use a simple label, on First Amendment speech issues, and this is a case where the court came out the other way. The court also showed greater credulity to the government's presentation here, submission, that this is what we need to do in order to protect minors from sexually explicit speech. And obviously it's big business, commercial pornography online. So possible trends to watch in First Amendment speech law going forward. The other case that I want to...
6-3 decision, correct?
6-3 decision. Other case I want to begin to talk about, and Professor Appleton is actually going to pick this up, we're sort of tag teaming it, is a religion case called Mahmoud versus Taylor. This is a case where a grade school was using, as part of its curriculum for teaching reading and writing, some books that depicted LGBTQ plus people and same-sex couples in a positive light. In a normal light, I would say. And some parents in this school district objected and argued that they should be able to pull their children out of instruction using those materials because using those materials would violate the family's religious free exercise rights. These are, I believe, all Christian families, conservative, theologically conservative Christian families. And the court sustained the family's First Amendment free exercise challenge and said, yes, you have a right to opt out of using these materials. There are a lot of things to talk about in this case, but I want to briefly cover why this case is significant as a matter of constitutional free exercise doctrine. There is a 1990 precedent called Employment Division versus Smith, where the Supreme Court largely foreclosed what are generally called religious accommodation claims. A religious accommodation claim is a claim where a religious believer challenges a neutral, generally applicable law and says, even though that law is generally constitutional, it should be held unconstitutional as applied to me. Because even though the state was not trying to interfere with my religious exercise, applying that law to me has the effect of interfering with my religious exercise. For a while, before 1990, claims like that were quite available and quite robust. But in Smith, the court substantially foreclosed those claims. Mahmoud versus Taylor sustains a claim exactly like that. And for several years, the question has been bubbling around, will this current Supreme Court overturn Employment Division versus Smith? Now, it's tricky for a court with a conservative majority because Smith is a rights-limiting decision, and it's an opinion authored by Justice Scalia, the late leader of the court's conservative wing. But on the other hand, it's a case that cuts against claims of often religious conservatives asserting religious liberty interests. So the court in Mahmoud doesn't overturn Smith, but it distinguishes Smith in what I would say is a very disingenuous way. It says, oh, this is exactly like one of the handful of cases that Smith carved out and said were okay. And without going into more detail than I have time for, Mahmoud really isn't like those cases. So it's one of those cases where the Supreme Court distinguishes a precedent. It's hard to take the distinction seriously, and that dynamic raises the question, is this really a step on the road to overruling the precedent? And that's what I think is worth paying attention to on the free exercise side going forward based on Mahmoud.
6-3, right?
I believe so. It's funny how that works.
No.
No.
Okay. So I'm here to discuss cases raising issues of family, sex, and gender. And in terms of an overview or the general vibe, I think we can see that the restrictive turn that was exemplified in 2022 in the Dobbs decision overturning abortion rights continues in adjacent contexts, whether Dobbs is cited explicitly or not. What we see are rulings that consistently leave unprotected departures from traditional, even hidebound notions of family, sex, and gender. I want to begin by asking Professor Magarian a follow-up question on Mahmoud, which he discussed. And to what extent do you see this only as a religion case? That is what the court focused on. But to what extent is it a case about parental rights and parental control of children at the same time?
So the claimants didn't raise a or at least the court didn't consider a substantive due process constitutional claim about parental rights, but I think it's an important case about parental rights, maybe in even a larger context of opt-out rights. Like there was a case a few years ago where the court on free speech grounds allowed a vendor of websites not to provide services to a same-sex couple because the court held that would be compelling speech on the part of that vendor. And so we're seeing this pattern of letting people opt out of other, sort of ordinary social legal regimes, and parenting is probably the most important context where that kind of opt-out comes up and matters.
Yeah. I think to the extent it is a parental rights case, even if that's just a subtext, I think it is of a piece with various other government moves we're seeing, like President Trump's executive orders saying that gender ideology and discriminatory equity ideology are banned from K through 12 schools, and the executive order itself cites lots of references to parental rights. I think it's interesting in this context that the Mahmoud majority relied extensively on Wisconsin versus Yoder, an earlier case that allowed the Amish parents to take their kids out of school after the 8th grade. But that case is also famous because there was a powerful opinion by Justice Douglas, who wondered whether anyone had bothered to ask the children what they wanted in that case. And here I wonder about the same thing. To what extent can we imagine that maybe one of these opting out parents might have, say, a gay kid who would like to attend the lessons that are not going to be offered to that particular student? But Mahmoud ignores that and lets parents speak for their children. I have another concern about the case on the ground, and that is that I think opting out is going to be so disruptive that it is going to mean that curricula follow a lowest common denominator approach, and anything that might be so controversial that parents would opt their children out will be excised from the curriculum and not available at all. So some parents' religious beliefs will determine the curriculum for everyone at the school. So if Mahmoud is my case about family, U.S. versus Scrimetti is my case about sex and gender. And there the court upheld the constitutionality of state laws that ban gender-affirming medical treatment for minors on reasoning that such laws don't operate on the basis of sex and therefore trigger only rational basis review. Citing past precedent, including an employment discrimination case, Bostock, challengers of the law had said, and this included the United States as a challenger, had argued that banning the use of testosterone only for transgender boys and banning the use of estrogen only for transgender girls amounted to sex-based discrimination requiring heightened scrutiny. But the court, although it didn't cite Dobbs, it parroted its conclusion that restricting a medical procedure that only one sex can undergo does not discriminate on the basis of sex and therefore doesn't merit heightened scrutiny. Dissenting Justice Sotomayor condemned the majority's approach as running counter to decades of equal protection precedents. I think it's interesting that there was a parental rights issue in Scrimetti in the court below. The Sixth Circuit said that even despite parental rights to direct the upbringing of their children, parents could not opt in to gender-affirming care against the state ban, even if they thought that, in consultation with their doctors, that that was the best medical treatment for their children, and medical professionals had agreed. The court below, the Sixth Circuit, cited Dobbs' methodology, saying that this particular right these parents were asserting was not recognized in 1868. But the Supreme Court did not address that issue, and I suppose it remains out there somewhere, finally to be resolved. And then finally, one last case from this past term is within my remit. This is Medina versus Planned Parenthood of the South Atlantic. There, the court ruled that the provision in the Medicaid law that entitles recipients to use any qualified provider does not clearly and unambiguously confer a private right upon a Medicaid beneficiary to choose a specific provider. So despite the provision in the law, the government can refuse to allow Medicaid payments to certain providers like Planned Parenthood clinics, regardless of patient choice. I think the case is much bigger than that because it invites a very narrow reading of statutory rights that one has the ability to sue to enforce. New York Times columnist Linda Greenhouse referred to the court's move as, quote, the project to detach rights from remedies. And she noted that the Medina approach has already affected some voting rights litigation that predated Medina. Looking ahead, parental rights in the context of sex and sexuality will be before the court again this term too. The court will hear Childs versus Salazar challenging Colorado's ban on conversion therapy for minors as a content-based restriction on free speech of counselors who claim it's a violation of their First Amendment. The court below applied rational basis review to the restriction on the ground that the speech in question is professional conduct that the state has authority to regulate. A divided court below held that the law survived rational basis review because it was enacted based on, quote, overwhelming evidence that efforts to change a child's sexual orientation or gender identity are unsafe and ineffective. But Childs claims the law violates her First Amendment rights to free speech, and she says that she, as a counselor, given her religious beliefs, should have the freedom to talk with those she counsels about Christian values and learning to accept what God has ordained in terms of sexuality. Parental rights, I think, are implicated here too, because often it's parents who are seeking conversion therapy for their kids, sometimes over their kids' objections, and it'll be interesting to see how that issue might or might not play out, given that it was parental rights was avoided in the Mahmoud case. Other possibilities for the court to consider this year, I don't know, I've just seen little snippets in the news. Maybe the court will revisit marriage equality because there's a case asking it to do so. Maybe the court will take a case about interstate conflicts on abortion, where abortion providers in states that have shields send medication to abortion patients in states that ban abortion. But I'm going to pass the torch to Professor Epps now.
Just real quick, both of those, Scrimeti and Medina were 6-3.
Yes.
Yeah.
Well, I'm very grateful to have been invited to talk here on Constitution Day. A little bit about the prior term, because I do think this is a good moment to reflect back in advance of the upcoming term, but I'm going to be a bad guest and be kind of ungrateful because I'm going to talk about why the distinction between terms doesn't really matter as much today as it used to because of the rise of what is called, among other things, the Supreme Court's shadow docket. And I'll begin with a little anecdote. In 1983, a young lawyer in the Department of Justice wrote a memo, and the memo was very critical of the Supreme Court's practice, where it would get all the opinions out by late June, and then the justices would go off and have European vacations and not reconvene again until early October. He wrote, only Supreme Court justices and school children are expected to, and do, take the entire summer off. But this lawyer saw one upside, which is that we know that the Constitution is safe for the summer. That lawyer was named John Roberts. He's now the Chief Justice. And because of the increasing importance of the shadow docket, I'd say the Constitution, depending on your views, the Constitution is no longer safe for the summer because the Supreme Court is deciding really, really important decisions all the time because they come up in this shadow docket posture. What is the shadow docket? It's sometimes called the emergency docket or the interim docket. But basically, these are cases coming to the court where a case in the lower court is still kind of in this preliminary posture. Typically, a lower court has granted an injunction, quite often against the government. There's different flavors of this, different varieties, but that's the kind of core case. So, let's say a district court has granted an injunction enjoining the administration from doing something. And so the government, it doesn't have to be the government, but the government typically will run to the court and say, you need to give us a stay of this injunction, like this week, or else this is going to happen and all these bad things are going to happen. And in theory, the court, is, when it's considering these things, it's issuing rulings that are preliminary. Whether to grant or deny injunctive relief is supposed to turn on equitable factors, of which kind of the likelihood of success on the merits is one factor, but not the only one. There's other factors like irreparable harm, balancing the equities, and so forth. But in many cases, what we're seeing is the Supreme Court's resolution of really significant issues in this fast-paced emergency docket posture ends up being effectively final because sometimes the case can become moot because the court is stopping a lower court from intervening, or because the Supreme Court just signals its underlying view of the merits so clearly that it kind of resolves the legal issue for everyone. And it's an area where the court has come under increasing scrutiny and criticism because these cases are typically decided on a tight timeline. The government doesn't hold argument, it doesn't get a full set of briefing, and it often doesn't explain why it has done what it has done at all. Sometimes the court just issues an order and says, the order of the district court is stayed. With no explanation. Sometimes they issue an opinion that's a few sentences. Sometimes there's a per curiam that's a few pages. But certainly these opinions are not as, such as they are not as developed and clearly reasoned and clearly explanatory the way that an opinion in what we call a merits case is, right? A case that comes up during the normal process. There's briefing, there's argument, it takes them months to rule on. And so, there are many cases that have been decided in this posture recently. Some of them technically qualify as last term, some of them technically qualify as this term. I think just based on the docket number, some of them, the docket number starts with a 24, some of them it starts with a 25, but the distinction really no longer matters because they're happening all the time. We got a big one last week. There are so many, I can't summarize them, and I was, when I was trying to prepare for this talk earlier today, I was just scrolling through and trying to pick out the ones I thought were most notable. But just to give you a few examples, one I think Professor Katz is going to talk about a little bit more, but in several cases the court has stayed orders of lower courts that had barred President Trump from removing members of independent agencies. And in so doing has arguably overturned very, very significant long-standing Supreme Court precedent with very little explanation of why it's doing that. The court has overturned rulings ordering the government to reinstate thousands of government employees who were fired allegedly in contravention of civil service protections in National Institute for Health versus National Public Health Association. The court overturned a lower court ruling that had barred the National Institute for Health from canceling many millions of dollars in grants for medical research. In Department of Homeland Security versus DVD, the court stayed a district court order barring the government from deporting individuals to a third country without giving them a chance to raise arguments under the Convention Against Torture. They did so with no explanation. Just last week in Nome versus Perdomo, the court stayed a district court order that had enjoined federal immigration authorities from stopping and detaining individuals suspected to be illegally present in the United States on the basis solely of appearing Latino, speaking Spanish, congregating at a place where immigrants are believed to gather and doing certain kinds of work. like day laboring. So these are people gathering at Home Depot to be picked up for day laboring jobs. Court did that without any opinion. There's a concurring opinion, but the court itself did not explain why it was doing that. Various other things I could mention. Now, the court hasn't ruled for the administration in 100% of these cases, so it did require the government to take steps to facilitate the return of a man named Kilmar Abrego Garcia, who had been illegally removed to El Salvador and imprisoned in a prison notorious for human rights abuses. And it did allow a class of immigrant detainees whom the government was trying to whisk out of the country over the weekend an opportunity to challenge their deportations. But more recently, there has been a really nearly unbroken string of wins for the government. And the court has also, I think, taken steps that disempower lower courts from doing things in a preliminary fashion to stop the government from doing things that lower courts believe to be lawless. Perhaps most importantly, in Trump versus Casa, the court issued a major ruling declaring that district courts no longer have the authority to issue what are called universal injunctions, which categorically bar the government from engaging in illegal conduct that affects many people and not just the particular plaintiff who filed suit. The court is now taking the position that every time the government is not allowed to do what it wants to do, every time a lower court bars the government from doing something, that constitutes irreparable harm, entitling the government to run to the court and try to get a stay of an injunction. And some justices, including Justices Gorsuch and Kavanaugh, have started to chide lower courts for not following the court's signals in these shadow docket cases, even though those signals are often very hard to follow because the court is giving very little explanation. But now the court seems to be taking, or at least some of the justices seem to be taking the position that these count as major precedents that lower courts have to follow and kind of read the tea leaves. And district courts judges themselves have made comments suggesting that this has now made their job a lot harder because they often don't know why the court has done what it has done, precisely because the court has given such little explanation. And the result has been a pretty remarkable stripping of authority from the lower courts to stop perceived lawless action by the Trump administration. And we are going to see a ton more of this, I think, in the years to come. In the months to come, there's a lot of things bubbling up in the lower courts that are going to reach the court, and the court, for better or for worse, is going to rule on those in a very expedited fashion.
Thank you.
Can I ask you, say a little bit more about these shadow docket cases procedurally? Like, some of them you're describing as establishing precedents, but a lot of them are decisions on motions for stay pending full resolution, right? So what's the sort of the ultimate, and obviously the interim status matters on a human level, but...
Yeah. Well, so, to the extent, some of these cases, they are just a motion for stay, but to the extent that the court says, even briefly, we are granting this relief because we think the applicant is likely to succeed on the merits, that's a legal ruling, right? And then the court has said, in a much more abbreviated fashion than it normally would, but it said that we think this legal issue this is the right answer as to this legal question. And again, I don't want to take the wind out of my colleague's sails, but it did so in a very striking fashion in these cases involving removal. And in theory, these decisions are supposed to just be equitable, case-specific, balancing various considerations, but to the extent the court is leaning in to just saying, well, we're going to just rule on the likelihood of the merits. If you say a party's likely to win, you're saying the party is going to win, and you're saying what the legal answer is.
Okay, all right, I'll pick up there. Yes, I think the prior emphasis, there's that old saying, procedure is politics. I think that couldn't be more true right now. So in a sense, I think that the most important topic to focus on from this panel are Professor Epps's remarks. I think that's what we need to really zoom in on. But anyway, I've been asked to speak about removal, so I'll get into that. There's a very old and a new component to this aspect, to this issue. So presidential removal, the power to fire officers in the government, is one of the longest running debates in our Constitution's history. On one side of the debate, you have what are called the presidentialists, who believe that Article 2 of the Constitution includes a power to fire officers, even though this is not stated in the text. It is implied, they argue, under the executive power as part of the job. Okay. On the other side, you have defenders of congressional delegation, right? This is the idea that because the Constitution doesn't tell us where the firing power is, it falls to Congress to say who can fire what officer of government and when and for what reasons. Okay, so here Trump again represents something old and something new at the same time. Every president in American history has used removals to try and imprint their agenda on the government to some extent, with the twist that removal itself has increased in prominence since the late 1970s. You had conservative presidents like Nixon, Reagan, and thereafter the Bushes, presidents who generally favored deregulation and reduced power for independent agencies like the SEC or the CFPB, right? Embracing removal as a tool to shrink the government and the scope of regulation. So Trump is following that same playbook, decades old, but he's also rewriting it. No president has fired in the way the Trump administration has. So by one count, we have something between 200,000 and 300,000 firings carried out or announced. As for who's being fired, this too is eyebrow raising. The fired officials include inspectors general and public watchdogs. They include scientists publishing information that the administration disagrees with. It includes probationary employees who by law are not supposed to be fired. It includes even whole agencies altogether, right? USAID was famously emptied out using the firing power. And it also includes heads of what are called independent agencies, right, as Professor Epps mentioned. Okay, so I don't have time to go into the different cases, but what I thought I would do would be to focus on one case in particular to highlight what I think is an emerging pattern, okay? So I'm going to talk about the Consumer Product Safety Commission, all right? So this is an independent regulatory agency that was created by statute in 1972. The CPSC develops safety standards and coordinates recalls for things like children's toys that pose a choking hazard or electronics like Paris Hilton's new mini beauty fridge that have a burning hazard, okay? So that's what this does. Trump fired 3 members of this commission. They had been appointed by President Biden to serve 7-year terms that were supposed to end in 2027 and 2028. Upon taking the case, a district judge in Maryland, where the agency is located, held this firing illegal and ordered the 3 fired commissioners reinstated, right? The remedy was that they had to have their jobs back. Okay. The circuit court affirmed. The Supreme Court in July issued an unsigned opinion, 6-3, staying the district court's order to reinstate the commissioners. The court defended the stay, and they argued, as has just been discussed, that the firing should be allowed for now on the grounds, as they said, in light of, quote, our judgment that the government faces greater risk of harm from an order allowing a removed officer to continue exercising the executive power than a wrongfully removed officer faces from being unable to perform her statutory duty. Okay, this is a very callous way to treat somebody who is unemployed now. But anyway, whether that test makes sense or not is kind of in the realm of civil procedure. But what I want to say about it, I think the most important thing about a case like this is the pattern. You see the lower courts, especially the district courts, appear to be scrupulously following the law and prior precedent, right? The reasoning was the statute says that the CPSC commissioners can only be fired for cause. No cause was given because they were fired almost instantaneously when the Trump administration took office. Therefore, this firing is illegal and the commissioners have to get their jobs back. Okay. Then the Trump administration appeals these holdings for emergency relief, goes to the Supreme Court, and the court has in general been giving them temporary wins by allowing the policy to continue while these cases make their way through the courts in the slow fashion. So we see what was just discussed. The Supreme Court is acting quickly, generally along party lines, giving little reasons for its decisions, but also giving itself room down the line to craft a new rule of presidential removal that does away with precedent entirely. And here the case that's potentially on the chopping block is Humphrey's executor. There's a really interesting question about whether these temporary rulings have effectively done away with that precedent sub silentio altogether. Okay. just want to note very briefly, Justice Kagan's dissent in the Consumer Product Safety Commission case accused the court of doing exactly this. She said they were using the emergency docket to facilitate the permanent transfer of authority piece by piece by piece from one government to another. So this is the power, again, to fire. I don't think there's very much good to say about this episode or this pattern we're seeing. I think the speed question, again, as Professor Epps noted, is critical. Also, the reason-giving function, as Professor Tokarz mentioned, there was a New York Times article today that suggests that when the court decides under pressure, it tends to decide in a hasty and particularly politicized way. So I think generally we should distrust these sorts of rulings, especially when they have the effect of making law down the line. When it comes to firings, the administration is getting only a temporary win, but imagine how this plays out in real life, right? The fired officers are not waiting around to see if they'll get their jobs back, right? They leave. So letting these policies stand temporarily has a couple of effects which I think are very important. They might prevent agencies from acting at all. They weaken trust in these agencies, obviously. They water down the desirability of government jobs for future law graduates like many of you. Big picture, I think this pattern allows the president greater leverage in shaping the government in his own image, despite whatever Congress might think. And I think worst of all, from a long-term point of view on the presidency, it allows the office, it gives the office incentive to govern, so to speak, through a blitzkrieg of executive officers, knowing that the courts are going to be too slow or too compliant to really do much to stop these actions from happening. So I wish I could leave you with cheerier news, but that's kind of what I have to say.
Can I ask a follow-up that kind of combines our two topics, which is recently the president tried to fire Fed Governor Lisa Cook, and that's now going to make its way up to the court on the shadow docket. The D.C. Circuit has refused to let that go forward. The court in Wilcox sort of tried to distinguish the Fed from other agencies in a way that was not particularly persuasive. What do you think the court's going to do here?
I think the court signaled, right, so to the extent, so we have these like unsigned opinions, and we're a little bit reading tea leaves right now, right? These are like 1 to 2 paragraphs, and again, the court is saying that these are not decisions on the merits, but then they're suggesting that they may indicate which way they're going to go, especially, as Professor Epps said, if the Supreme Court believes that the lower courts need to be, holding faithful to these temporary orders. Okay. In the Wilcox case, which involved the firing of an NLRB commissioner, the court explicitly carved out what a banking scholar at Columbia, Lev Menand, is calling the Fed exception. Okay, this is the idea that independence from the president's power to fire is unconstitutional everywhere except for the Fed, because the Fed presumably has a unique structure. It's a quasi-private agency that carries out banking regulation and does not exercise executive power in the way that these other agencies, the NLRB, the CPSC, the MSPB, do. Is the court likely? I think they are dropping breadcrumbs that they want to preserve Fed independence. I think, again, most scholars don't think that this is a cogent carve-out, but that could be a rule that we see coming down the line on the merits when the court comes to these cases, that the president must be able to fire all officers except for the Fed Board of Governors.
Any other thoughts, questions, comments?
I don't think we got to ask Professor Appleton a question, so if you don't mind. I was wondering if you can leave us with something holistic about where parental rights are going, because I'm sort of confounded by conflicting trends. The court has shown its disfavor for substantive due process, which is really the home in our Constitution for family rights. Are they going to be sort of tucked under the First Amendment? Is that your prediction, possibly?
Or maybe the Privileges or Immunities Clause, which Justice Thomas has repeatedly said he wants to provide as an opportunity for a do-over of substantive due process. And I think Alito included a footnote along those lines in Dobbs. So you could say that parental rights are really bedrock. There was an earlier case, Troxel versus Granville in 2000, where Justice Thomas even though the rest of the court didn't say what standard of review should apply to infringements on parental rights, said that strict scrutiny ought to apply. At the same time, I think it depends on context. I don't see parental rights carrying the day when parents want their children to have gender-affirming care. But parental rights might carry the day in a case like Mahmoud, where it's a more traditional conception of family, sex, and gender. So I think it's very situation specific.
I have one quick question for everybody, which is Justice Sotomayor was here. I had a good conversation with her, and some of you probably have read some of the comments that she has made, including dissents, where she's talking about bad law, horrifically bad law that is being made. What do you think about what she's saying publicly, and what do you think the impact is, if any, for public comments?
So I'm going to go back to something I mentioned briefly. Obviously, Justice Sotomayor is on the court's liberal wing, and the conservatives have the majority, and so she is going to disagree substantively with much of what the majority does, most of what the majority does in constitutional cases. And we could sort of dismiss her complaints at a certain level as just ideological disagreement. But we are in this interesting situation where for decades the court was, if not exactly evenly split, there's been a conservative tilt for a long time, but there were always justices in the center who were somewhat unpredictable, for better or worse, and a fair variety of substantive outcomes. So it's, a conservative-leaning court is the court that constitutionalized same-sex marriage, for example. That happened. That kind of thing happened a fair amount. Now we have a really strong majority. It happens to be a strong conservative majority, but I think you can level similar complaints at this majority that one might have leveled at the Warren Court liberal majority in the height of its power. There are, as I said before, the most important constraints on Supreme Court power are internal. Reticence to act. And the strongest source of that reticence is when there are justices within the court who say, okay, we don't want to move boldly in this or that direction, let alone move boldly in an ideologically consistent direction consistently in over a run of cases. That's happening, and I think it is very possible to see some of the developments we've been discussing, the overuse of the shadow docket, the refusal to explain substantively the grounds for opinions, as characteristics of a majority that has grown arrogant because of its strength. Not because of its substantive ideology, to be clear, but simply because of its cohesion and its attendant strength. And I think that's something, well, that element, whatever you think ideologically of the merits here, and I got my own views about that, but I think that other level is well worth paying attention to and thinking about what the court is doing.
Let me just follow up very quickly on that. I think it was yesterday, right, that the Judicial Conference of the United States was held. And I think unusually in that, there was some reported controversy with lower court judges telling the Supreme Court, like, what's going on? We can't follow these orders. Why do you keep overturning us, issuing stays on our orders? So I think another thing to watch is this sort of, I think this very much echoes what Professor Magarian just said. I think the court is showing its sort of belief in its own sort of strong position by the fact that the lower courts seem to be following precedent, and the court is kind of creating this space where it may overturn precedent and kind of giving hints to the lower courts that it's doing so, but without really providing specifics. I mean, I also thought another interesting detail to come out of the Judicial Conference was that the court is facing maybe a budgetary crisis. I think there's a sort of irony there, right? The court sort of on high, perhaps changing the law in this unaccountable way, but then saying like, hey, we need extra money from Congress. I mean, I think it's worth remembering that Congress does have political controls over the court if it wishes to use them. Perhaps we're seeing indications that that mechanism might be kind of rising.
So every year I am so impressed and grateful that we have such brilliant, insightful faculty here who give us such interesting perspectives. I would say please take up Greg's suggestion, Professor Magarian's suggestion, to talk with faculty if you have questions, ideas, suggestions, concerns. I also want to urge you to take advantage of the free New York Times subscription. It's not for faculty, it's only for students. Maybe I should take a course. It might be cheaper. Last thing I want to say is come up here if you have other thoughts and questions with it. Are really crucial. I want to urge you to go to, there's a talk tomorrow at noon with Judge Jane Kelly. And I know a lot of those talks typically talk a lot about potential clerkships. But I know Jane Kelly on the 8th Circuit. She's the only woman on the 8th Circuit. She's one of the very few former federal public defenders who's on any of the circuits. But I know she has lots of things that she's willing to share and talk about, and I think you could have an interesting conversation with her. It's probably in 401, I'm not sure, but she's really terrific. I'm sorry we don't have time to take questions, but come up if you feel an urgency. Otherwise, thank you all. This was really good.